So welcome everybody. This is the webinar on duty to make reasonable adjustments, and Rory and I are going to take you through a half hour on that duty. This is part of a series of three, so we're the second. Some of you may have attended the first one on the definition of disability, and today we're going to look at one of the most difficult parts of the disability discrimination rules, the duty to make reasonable adjustments. And then just please do join us on the 26th of March, which will be the third of our series on um, the practical issues of managing disability-related concerns. Three housekeeping matters, if I may. We are recording this, so just please be aware of that. And please do make it available to colleagues who may not have been able to attend today, and we'll make it available widely on our website. There is a Q&A box in on the Zoom call, so if you've got questions as we're going along, please type into that. We'll talk for half an hour for the presentation, then we'll stay on and answer some of those questions. So please join us for that if you want, but obviously if you have to go at that point, then that's fine. But any questions, type them in and we'll try and pick them up at the end. And then finally, just a plea for feedback. We find it enormously helpful to get feedback, and you know, to let us know what goes well and maybe what doesn't go so well, so that we can incorporate that into our future webinars. So today we're going to, as I say, look at reasonable adjustments, and Rory and I are going to look at that in four aspects. Firstly, and very briefly, who is protected. Rory will take you through that. Then we'll look at when that duty to consider and make adjustments arises. The third section will be Roy and I looking at reasonable adjustments. What is reasonable? Probably the single most difficult question that you face as an employer. And then Rory is going to look at some practical points about managing adjustments in practice. So I'll hand you over to Rory now on the protections and the Equality Act itself.
Perfect. Thanks, William. So the duty to make reasonable adjustments has been described by the Equality and Human Rights Commission as a cornerstone of the Equality Act. And as you can sort of see on the slide there, in contrast to other areas of discrimination law, the duty can require an employer to treat a disabled person more favourably than it would treat others. So this duty can require positive and proactive steps taken by an employer. Now, its aim is to remove, reduce, or prevent obstacles a disabled worker may face in the workplace. Large organisations have higher standards expected of them than smaller organisations, given that they're more likely to have more resources to make any potential adjustments. And failure to make reasonable adjustments is probably the most common discrimination claim we see in the employment tribunal cases. If the duty isn't complied with, a disabled worker can show that there were barriers you should have identified and reasonable adjustments you could have made. They can bring a claim for unlawful disability discrimination. If they are successful with that claim, you may be ordered to pay them compensation as well as making that reasonable adjustment they've requested if they're still in employment. And the compensation for any award that might flow is high, as such awards from discrimination claims are uncapped, as most of you probably know. Now, who is protected? So the duty relates to all disabled workers and to disabled job applicants. Now, job applicants includes someone who's actually applied for a job, as well as someone who has notified the employer that they might apply. And there are lots of examples of cases of failure to make reasonable adjustments in a recruitment context. Your organisation should have its own procedures to follow for issues that might arise during recruitment. So it's worth being aware of what your policies are in respect of recruitment. Now, when does the duty to make reasonable adjustments arise? We've set it out on the screen in sort of at a high level. There are four main steps basically to decide if the duty is engaged and if an employer is under a duty to consider to make reasonable adjustments. Similarly to my recruitment comment, though, please note that your organisation might commit to providing adjustments in a wider range of situations than the pure basic statutory requirement. So do check your specific policies and procedures in this respect. Now, the first block there, an individual must have a disability, and that's sort of underlined on purpose. That's obviously the key word. We looked at what the definition of a disability was in the last webinar, so it's worth checking that out if you missed it. The only thing to add following that webinar is that it's sensible for employers not to attempt to make a fine judgment as to whether a particular individual falls within the statutory definition of disability at an early stage, but you should instead be focused on meeting the needs of each worker and job applicant. That's a point that's specifically made in the EHRC code, which covers the duty to make reasonable adjustments in detail and which can be used in evidence in tribunal proceedings. Now, the second block there, it must be something which places a disabled employee at a substantial disadvantage. And we're going to come back to those points shortly. Thirdly, an employer must have knowledge of the disability and the substantial disadvantage. And finally, the adjustment must be reasonable. So coming back to the something I mentioned earlier from block 2, the duty to make reasonable adjustments only applies where there's something that puts the disabled person at a substantial disadvantage. Now, that something, in inverted commas, could be one of three things, which you can see on your screen there. But firstly, it could be a provision, criterion, or practice, which we often shorten to PCP in the trade. Now, a PCP can be a formal or informal practice, a policy, or an arrangement. And in those cases, the employer must take reasonable steps to avoid any disadvantage thrown up by that provision, criterion, or practice. So, an example here could be an employer operating a policy that designated car parking spaces are only offered to senior managers. A reasonable adjustment to that policy could be to give a worker with mobility problems a space, close to the office door instead of reserving them all for senior managers. The second is physical feature. So this can be pretty much as it says on the tin, really, steps up to an entrance, your toilet facilities, clear glass doors that might be a hazard for someone who's visually impaired, anything like that. Now, the requirement would be to take reasonable steps to remove or alter that physical feature or provide a way for the disabled employee to avoid it. And finally, we've got auxiliary aids. So that is a specialist piece of equipment, for example, an adapted keyboard, text-to-speech software, etc. And basically the requirement there is going to be that you take reasonable steps to provide that auxiliary aid. Now, in terms of what might be a reasonable or potential adjustment, I should say potential adjustment, the EHRC code sets out a number of examples here. So you've got them on your screen. I won't run through them all. You probably all see this type of thing in practice anyway. But these are the type of things that could be a potential adjustment. Altering hours of work, allocating duties, transfer to an existing vacancy, etc., etc. There's plenty there, and I'm sure you've got plenty of examples of your own.
So I'm just going to pick up on that helpful flow chart that Rory spoke about, the second and third aspects of the consideration that you have to give. And the first is whether the disadvantage to the disabled worker is substantial or not. Now, the Equality Act says that substantial is more than minor or trivial, which actually is not a very high threshold at all. It doesn't really make the case for substantial in those words at all. So do beware of that. It's not something that has to have a significant impact, a significant disadvantage for the disabled employee. And the EHRC code goes to say there's actually anything that goes beyond the normal differences ability. So any impact that it might have on the disabled worker is going to be considered a substantial disadvantage, i.e. something that you're going to have to look at in terms of adjustments. But it is obviously important to identify the nature and extent of that disadvantage. Those two aspects are key. So you're going to want to understand what it is that the disabled worker says is causing them difficulty in the workplace, in any of those areas that Rory explained. So what is the nature? Is it a PCP? Is it a requirement on the physical premises, or is it an issue around aids to do the work? And it can, commonly be things around time off work, getting to work for a particular time, etc. And then you've got to consider the second aspect, which is the extent of that disadvantage. How is it specifically affecting that worker with that particular disability? It is an objective test. It's a test that you can look at as an objective matter. It's not simply for the disabled person to say this is what I need. Ultimately, you will determine whether the substantial disadvantage is there or not. So let's look at an example of that from a recent case, a case that was heard last year, where the Employment Tribunal's decision was overturned by the Employment Appeal Tribunal. In this case, Mr. Gibbon suffered from depression. He had time off work, and there was a context of difficult working relationships with his managers. And in the course of this situation, the council discovered inappropriate material on his laptop and disciplined him for that. And they gave him a final written warning for what they discovered on his laptop. And Mr. Gibbon challenged that um, on the basis of failure to make reasonable adjustments and other claims. And the Employment Tribunal held in his favour and said that the council had failed to make reasonable adjustments because they had gone ahead with a disciplinary when he had depression, and they had issued the sanction to him when they shouldn't have done. The PCP in that case was the fact that the council said, well, we will investigate misuse of our IT systems, particularly where it's inappropriate material. The EAT overturned that decision and found that the Employment Tribunal had made two significant errors. The first error was that they hadn't set out to identify the particular disadvantages. And what the EAT said was that Mr. Gibbon's condition, his depression, really had two particular disadvantages that the council needed to consider. The first was whether the risk of depression would be made worse by the disciplinary, i.e., should they delay the disciplinary, wait until he was fit to attend a disciplinary. And then the second disadvantage would he be able to participate in the disciplinary? Would he understand what was going on? Would they need to do it in a different way or in a different place, or have breaks, etc.? But the point was the ET had not identified those disadvantages and had not heard any evidence at all as to whether those disadvantages existed in relation to Mr. Gibbon's condition, in relation to his depression. And without any evidence to determine that, then that substantial disadvantage couldn't be found. And so the council couldn't have failed in their duty to make reasonable adjustments. So it is evidence that is key in this. It is important to understand what the disadvantages are and to decide on evidence, with as much evidence as you can find, how those impact on the disabled person. The adjustments then are tailored and can be considered as to whether they're reasonable or not. The second error that the tribunal made, just for information, was that they also assumed that Mr. Gibbon was actually on sick when he was disciplined by the council, but as a matter of fact, he was not. So the question then is, well, what if you don't know? What happens if you don't know about a disability or any adjustments? Well, if you don't know about a disability, then you won't discriminate against a disabled person. You can't discriminate without knowledge of the disability. And secondly, the disabled worker will need to provide evidence to you, will need to help you in understanding the duty to carry out adjustments. Having said that, there is a duty on employers, and there's plenty of cases which say that if an employer ought to be aware of a disability through the way that the employee is conducting themselves, for instance, then you should make inquiries into that. You should look into the situation and do what is reasonably expected to find out. Um, so um, you will need to, if you're considering this issue, try and gather all the information that you can. So that will be um, people that work with the person to see if they've got any comments on it. You'll obviously be looking for medical information from fit notes or from uh, questionnaires that they may have completed. Look out for warning signs, rational behavior, sickness, absence, etc. And as I say, you should make further inquiries if there is a concern. Um, there is a tension here, obviously, between, on the one hand, saying, well, if we don't know, we can't discriminate on the other, complying with this duty. And as Rory said, in relation to fine distinctions about the definition of disability, generally it's tactically going to be better to get this out into the open, to find out as much as you can to narrow down the issues around what the disadvantage is, assessing how substantial that may be, and then what adjustments may apply to those particular uh, circumstances. Just a quick point as well on the collection of that information and carrying out those inquiries. Obviously, you have to maintain confidentiality on that and make sure that you're handling that sensitive information properly and fairly. So, one key aspect of those inquiries will be to consider whether to get a medical opinion, occupational health advice, and we've set out here on the slide some things that you would hopefully usefully find would find useful in contacting OH and seeking to inquire about the duty to make reasonable adjustments. The first question covers the point about understanding the particular impact of the particular disability on the individual and understanding how it affects them in their day-to-day activities. The second question will be to consider whether they have a disability. OH will generally say, well, this is a question for the courts, which is true, but they can at least tell you how long the person has suffered the condition, and as I say, the effect on their ability to carry out day-to-day activities. What is it that they are impaired from doing? That's the starting point. Then you can ask, thirdly, whether there are any adjustments to their tasks or to their working environment that may be needed. So we are looking there at whether there's a PCP that is getting in the way for the disabled person to be able to carry out doing their job. And it's worth pointing that out. If the employer's mentioned things that are getting in the way, then refer that to OH so they can advise you on that and consider the extent of that disadvantage. And then, as I say, following that logical process, then what are the adjustments that would be necessary to overcome that disadvantage, that substantial disadvantage, and then thirdly, how will those adjustments assist them in performing their duties to allow you then to assess whether, as we'll come on to, that is a reasonable adjustment or not. Then finally, you want to, obviously, if the person is off on long-term sick, you want to get them back into work. So then you can ask questions around the support they would need on their return. So those are, you do get to investigate, you do get to ask questions. Obviously, it's best to be proactive when dealing with OH to try and get the information from them that you really need in that particular individual circumstance. So that's the first two sections. The third section that we want to look at now is the issue of reasonableness, the difficult issue of what adjustments are reasonable. So I'm just going to highlight the factors that you have to take into account, and Rory will look at some of the practical some cases that show some practical light on this. So these are the six factors that you have to consider. Not all of them, of course, will be relevant in all cases, but you should at least think about whether they are relevant when you're considering the adjustments that you've been asked to make to enable your disabled employee to work effectively. And effectiveness, that first one, is really the most important of all. You don't have to make adjustments that won't have any effect, and if it won't work, then if it's going to be futile, then that's not something that you have to do. There are then the questions of practicability. How can you implement this? And this does include obviously taking into account other people in the team, the work levels, etc. You are if there's a reduced work output from the disabled worker, then you can obviously consider the impact that may have on the team and consider how that plays out. There's the cost of disruption of the adjustment, but bearing in mind with cost that you do also have to look as that fifth one is the availability of financial other assistance. Is there any access to work scheme funding available, which would defray the costs on the organisation? And obviously, size of your organisation and nature of your organisation will also impact. So larger businesses that maybe aren't charities, for instance, would be expected to bear more cost than smaller charities that don't have the resources available. Your resources are also an important factor, so you can take into account what you have available to make the adjustments. And as I said, the size and nature of your particular organisation will account, and as Rory said earlier, in relation to the considerations. If you're a bigger employer, then you will be expected to do more in terms of considering adjustments.
Brilliant. Now, I'm going to look at a couple of recent cases. I note that the slide should say 2024 for this citation, but not to worry. So, this is a case of Parnell and Royal Mail Group, and there's a quick summary on the slide, but I'll give you a bit of a background because that's the sort of the fun bit. So, Mr. Parnell was a postman who'd been employed for over 20 years. He suffered from anxiety and depression. He made a series of bullying and harassment complaints against his manager. Now, Royal Mail investigated these but didn't uphold any of his complaints. Royal Mail found that those complaints had been made in bad faith and subsequently issued Mr. Parnell with a 2-year warning under their disciplinary policy. Mr. Parnell was then off sick for over 2 years and refused to return to work until that 2-year warning had been removed from his record. A lengthy sickness absence process followed, with his employer eventually terminating his employment due to irretrievable breakdown of trust and confidence. Even with that 2-year warning expired, he still refused to return to work. Mr. Parnell ultimately brought a total of 31 claims to the Employment Tribunal, and all were eventually dismissed. But relevant here, one of those claims was a reasonable adjustments claim. He stated that his substantial disadvantage was that he was unable or unwilling to take a pragmatic view of the 2-year warning's implications, and his disability meant that this warning became the focus of his sense of grievance and exacerbated his impairments. Now, when considering his claim, the Employment Tribunal and the Employment Appeal Tribunal took the view that even had the warning been removed, there was no real prospect whatsoever of the claimant ever returning to his duties, whatever adjustment was made, including expunging the 2-year serious warning. Now, as Williams just said, the duty to make reasonable adjustments is practical in nature, and as there was no prospect of any adjustment, even the removal of the warning securing his return, then it was found that it wouldn't have been a reasonable adjustment to remove the 2-year warning because it actually wouldn't have helped. It's all about that what is practical in the circumstances. It wouldn't have been a reasonable adjustment. The second case we've got here is Rentokil Initial UK Limited and Miller. And again, brief summary on the slide, but to go into it slightly more, there's no need to be certain that any adjustment will work. So in this one, Mr. Miller was a pest control technician who was diagnosed with multiple sclerosis in 2017. In early 2019, Rentokil decided there was no viable way that Mr. Miller could continue in his role because of the physical demands of his role. In February 2019, Mr. Miller applied for a more junior administrative role, but performed poorly in the written maths and literacy tests for that role, and so his application was rejected. Now, there was no evidence at that time that Rentokil had considered any adjustments in relation to these assessments. In March 2019, Mr. Miller was dismissed and subsequently brought a claim. Now, the Employment Tribunal concluded that transferring Mr. Miller to the administrative role for a trial period would have been a reasonable adjustment. It thought that there was a reasonable chance he could have been able to perform better than the interview and tests suggested. The Employment Appeal Tribunal also upheld this decision, pointing out that the employer doesn't need to be certain that the adjustment would work. Now, in this case, the tribunal considered there was a 50% chance the trial would have been successful and Mr. Miller would have been appointed to the new admin role permanently rather than being dismissed on capability grounds. It had sufficient prospects of avoiding that dismissal, Rentokil, and so it was reasonable for Rentokil to have taken that step. Now, whether or not offering a trial period is reasonable in any other case does depend on the suitability of the alternative role and also the prospects of the employee succeeding at the role and obviously passing that trial period. And as a sort of a final sort of case, we've got Cairns and Royal Mail Group, so another Royal Mail one. And in this one, again, summary on the slide, but Mr. Cairns had a delivery role at a delivery office in London. Now, due to a disability, he was no longer fit for an outdoor role. There was no desk job available at his office, so he was dismissed by way of ill health retirement. Now, at the time of his internal appeal against this dismissal, which was about 3 months later, a planned merger of two delivery offices was about 1 month away. There was a possibility when that merger completed of being transferred to a permanent desk job at that merged office. And what the tribunal failed to consider at this point is that the tribunal failed to consider whether it could have been a reasonable adjustment to wait and keep him in employment for a short time, holding off dismissing until the merger was completed to allow the possibility of him going into that sort of job to be created. So that job that was still a month away at that point, that could have been a reasonable adjustment to keep him in that role. So those are the cases. Hopefully, that sort of gives some flesh to what William and I were sort of speaking about today. Now, managing adjustments in practice, this is obviously the sort of the key bit, really. How do we actually implement these bits and pieces? So, as sort of practical tips, what we would always say, and we've touched on it so far in this webinar, but you need to assess the situation. Consider the legal test, those four sort of blocks that we discussed earlier in the webinar, and also very importantly, get medical advice. Medical advice in these cases is going to be key to pointing you at what you need to do, telling you how an employee might be affected, how conditions might be, alleviated, or disadvantages, I should say, might be alleviated. Medical advice and occupational advice is crucial, and hopefully you took a lot from the slide with the OH questions on. You can also consult with the employee, or you should consult with the employee. Find out from the employee themselves what are those barriers to them performing sort of their role or whatever it might be. What might help them? What could the impact be? What is the impact on the rest of the team of any adjustments? And how are those adjustments going to work in practice? The third point there, so try and agree those adjustments, and the operative word is try there, I guess, but agree what you will try and plan to review and monitor the situation. The EHRC guidance states that whilst agreement is the best approach, it's not always going to be possible to agree, and I'm sure you've all had situations where that's been the case. An employer can still satisfy the duty to make reasonable adjustments, even though its proposals are not to the satisfaction of the employee. The fourth there is self-explanatory. Let's implement adjustments in a timely fashion because any delay could be sort of potential discrimination in itself. Regularly review matters, again, sort of fairly standard stuff, and also do ensure that you keep a record of what you've done, what you've considered, etc., etc. A, for the reason of passing, the proposed adjustments to potential sort of new managers if there's a change in management, because I've seen cases where actually an employer's done all they can, but one manager's forgot to pass it on to another in terms of adjustment, and then the employees complained that a new manager's not making X, Y, and Z sort of change. So make sure you keep a record, but also, of course, if there is a tribunal claim, you're going to want records that you can show to a tribunal to say, look, we did do X, Y, and Z. We considered these points. And yep, those are my practical tips.
Thanks very much, Rory. So we're just on time now. We've got a few questions if to look at, and there's been some interesting questions. Obviously, there's a huge range of specific issues around disabilities, but one question that has come in various forms is around the position of there being no formal diagnosis, or there being the employee not engaging and not telling you if what their condition may be, and whether the duty to make reasonable adjustments arises at that point. I think the approach you should take is that logical approach that we've been through in those scenarios, and uh, to tell the employee, to tell the person that's requesting these adjustments, that you do need to look into that. You need to understand uh, why these adjustments are necessary, and how it will have that how will it prevent that substantial disadvantage, and to say that you need evidence to be able to make a decision on that. If they refuse to provide that evidence, and there isn't any reasonable basis for assuming that they do have that condition, or that substantial disadvantage, then I don't think you have to go through that process of making adjustments. However, if it is clear that there is an issue there, and the adjustment is something that can be easily implemented, then you should implement that to avoid any kind of risk of a claim. So it is a balancing act, but ultimately you are entitled to act on the basis of evidence and information provided. And if they simply refuse to engage with that, then yes, unless there's very compelling reasons or very obvious reasons in relation to their condition, then you wouldn't be criticised for failure to make reasonable adjustments.
I can pick up a question, William. So I've seen a couple again around the theme of what about, we're talking about candidates who are applying, and another one, does it only start from employment? Again, to sort of reiterate, the duty does go to all disabled workers and to disabled job applicants as well. Now, one of the points sort of from the slides, of course, was, well, in term when considering reasonableness, one of the things that can potentially be considered is, you're more likely to have to make, or an adjustment is more likely to be reasonable, as it were, if it is for a long-standing sort of employee, rather than a half an hour job interview. That sort of balance is going to be there, but it still does kick in, and it is something that does often catch employers out, the making adjustments for job applicants. So yes, the duty does extend that far to candidates who are disclosing disabilities. Um, Another one,
Yeah.
again, slight theme I think I've got from these is a lot of more specific questions, but the general theme is, would it count as an adjustment if blah blah blah, something on those themes. And what I would say to that is, in the circumstances, and I think I said this earlier, but medical evidence is incredibly key. That's going to be your guiding force. Getting a diagnosis, understanding from the medical position what the actual issue is and what might alleviate it, is going to be absolutely sort of key here. Again, I can't summarize, each and every sort of question, but they're generally about that theme, and what is going to be a reasonable adjustment in that circumstance should potentially be, pointed to you by the medical professional. So it's really good to ask good questions of occupational health as to what might be a reasonable adjustment. Now, what they're suggesting are potential
Can I?
adjustments. The question then is reasonableness, and that then becomes a matter for the employer to consider.
Thanks, Rory. I just very quickly pick up on one other sort of theme of questions before we conclude. There's lots of questions around adjustments during other processes, for instance, attendance at work, sickness absence processes, or disciplinary processes. Again, just the key is to drill down into what adjustments are being requested. What specifically is the disadvantage that's being suggested? That's not to say that they can sort of absent themselves from the process altogether, as we saw in the council case, Mr. Gibbon. But the conduct of those processes, you should stop to think about what is the adjustment that's being requested and whether that's something that would be worth implementing. And in terms of sickness absence, then obviously if you are considering what future absences are tolerable, then you can factor that in with the knowledge that you have as to any ongoing substantial disadvantage. If they've been removed, if there's no substantial disadvantage, and you can expect the employee to disabled person to work without ongoing sickness absence, then you can set that as a target. Okay, thank you very much, everybody, for listening. I appreciate we've you need to get back to your desk. Can I just make one quick plea before you disappear to say, please do come to our conference that we're holding at the British Library on the 13th of March. It's centered around EDI and looking forwards, and we've got some fantastic speakers. And then secondly, we've got our People Matter, the third and final part on disability concerns on the 26th of March. The recording will be available and we can send the slides out to everybody. Thank you very much for coming, and I hope you have a good day.
Thank you.